So I'm going to start with the intro. Regulation is often perceived as a step behind innovation, a notion reinforced by the past decade with the rise of giant internet platforms. However, the recent move seems to signal a shift. In August 2022, the US FTC issued its first ANPR on AI, a critical step toward federal AI regulation. October 2023, President Biden released the first AI executive order. The same year, China adopted its generative AI regulation in August. And by December, the EU approved the EU AI Act. Is the world's first comprehensive legal framework on AI. It seems like the AI race is not only about large language model development and semiconductor supply chain race, but a global competition on AI regulation. But the question is, what is actually being regulated when it comes to regulating AI? Who are the stakeholders? How do we balance innovation, industry competitiveness versus ethical considerations and social responsibilities? Today, we're very honored to have a panel of experts to guide us through these complexities. JoAnn Stonier, who is a Mastercard Fellow of Data and AI, and a prominent data policy expert at the World Economic Forum. David Kappos, who is a partner and IP authority from Cravath, Swaine, and the former director of US Patent and Trademark Office. And Jeff Alstott, who is a technology policy expert from Rand Corporation and the former director for technology and national security at the White House National Security Council. Their diverse backgrounds as practitioners and policymakers will shed light for us on this dynamic landscape of AI regulation. Let's welcome them.
Thanks, Jack. He really set the stage. We've been talking all morning about a variety of topics. We looked at enterprise innovation. We talked about risk and regulation. But now when we start to take that conversation to a global stage and look at how the U.S. has reacted versus the EU, right? We heard there were guidelines. Many of us, say guidelines in quotes, put out this past year. The EU has the AI Act. So I want to start with Jeff, because you served in the White House. OSTP, sort of Arthi Prabhakar, who heads OSTP now, who came from DARPA, was the one that issued with Biden, the guidelines. When that came out, what's the initial reaction? Someone who had been in government, what is the reaction to those guidelines?
So AI is vast, and even though this conference is happening here today because of large language models, let's be clear, there's still a hell of a lot of other things within AI. And so people always ask me, what do I think about the AI executive order from last year, or the EU AI Act, or other such things? And man, I don't know. There's a hell of a lot of stuff in there. I've only been working on a few different pieces, which is about the frontier models, like the large language models, and the sort of national security implications of them, and the technology competition, tech risks of them. But there's, as I said, a lot of things going on in both that executive order and in the EU AI Act. And there are sort of many earlier antecedents to them in terms of sort of the AI Bill of Rights and things that the Trump administration did with an AI executive order, and so on. And I think that, generally speaking, this is all to the good of having sort of society through all both the sort of soft power guidelines versus real hard power laws of requirements, identifying what are the things that are our top concerns for how AI is used, both in industry, in sort of government, national security contexts, and other contexts. And what are the top concerns is varied based upon whether you're talking about a large language model versus facial recognition versus a self-driving car, using in a bank, and so on.
So obviously there's all these concerns. Data, we heard a little this morning about copyright and data usage. We saw, sort of Elon Musk's sort of, stories, these about stealing data, what Benioff said. So David, obviously that falls into yours. You start to think about IP. and again, especially data globally. Talk a little about, again, you were in patent trademark office now at Cravath. What are the challenges you're starting to see? What are these emerging lawsuits, mean to the future of developing policy and regulation?
Yeah, thanks for the question. So, we're going through a bit of a settling in phase, and just sort of bridging off of Jeff's comments. There's a lot going on, and it's not just about large language models. There's a whole world of AI that is, as was said this morning, largely rooted in the data. And we're going through a sorting out phase similar to what we went through at the advent of the internet 30 or so years ago. There's enough uncertainty about legal rights, particularly copyright, but not only copyright, that there's room to have disputes. And so we're seeing a lot of them. And so the New York Times lawsuit is a good example to start with, where there's a very strong position to be taken that fair use, which is, I think, hopefully we can agree, is a structural advantage that we have in the US. We have this robust doctrine that enables copying for certain socially beneficial purposes, and we are way ahead of the rest of the world because of the fair use doctrine. So there's a strong argument to be made in all of these cases, the New York Times case and the other ones, that the fair use doctrine should act as a backstop and permit, frankly, a fair amount of copying within certain limits. Now, what happened in the New York Times case is, so some clever Times queriers or prompt formatters were able to gradually get the generative AI model to regurgitate whole articles. That's not okay, all right? So that's not okay. But the models are going to figure that out. They already are. They're not going to let themselves do that anymore, even when asked. And the legal issues, I believe, are going to begin sorting themselves pretty quickly. This year, no, but in the next 2 to 3 years, similar to the internet. And we're going to see that our existing legal doctrines cover most of these issues.
So JoAnn, as you sit there, we hear words like uncertainty, navigating, unsure. You're at Mastercard, thinking as a global company and operating in all these different markets, trying to make sense of the difference between the AI Act and the EU. Here are the guidelines. You sitting on all of this, data. How does a multinational, how does a global company sit there and sort of figure out what the policies and the governance of your data is going to be, operating in all these disparate markets?
Yeah, so we operate in over 210 markets and jurisdictions around the world, so we are truly global, so let's start there. And so when you think about the issues, right, the EU Act is very different than the executive order, and it's different than the guidelines that the UK issued at Bletchley. And then the IP issues are another whole set of issues. And I think the New York Times case is interesting, but I think we have to also look at the societal implications of where does proprietary information begin and end, and also where does intellectual property and creativity begin and end. And so we're going to see, I think, we may see the law get settled, but I'm not sure we're going to see all the societal issues get settled. We look at the writers' strike, we look at entertainment, we look at how are we going to be creating into this new world and co-creating with AI. And I think our last speaker was talking about how are all of us going to be doing our work with AI. And I teach at Pratt Institute, and so I teach designers who are in a design management program, and truly designers of all types are really struggling with where will their creativity be part of kind of the process. But at Mastercard, when you look at the kind of disparate approaches, right? So the EU Act is a risk-based approach to using data and to using AI. And we've heard a lot today about open source, right? And the benefits of innovation. But when you're at Mastercard, we also have to look at the downside of innovation, because we do a lot of our AI models are for fraud prevention, cybersecurity. And so once we release open source, there's also the downside of how that will be used. And for us, we have traditionally gone to the highest common denominator, right? And we've set a governance process. And we heard Manuela talk about this, that the first time through, right, you go through a kind of a high level of scrutiny. But I think the risk-based approaches, and even the executive order kind of goes along with this, there's some commonality to this, that we are going to have to look at what are we trying to achieve, right? So what is the use, not just the output of AI or generative AI, but what's the outcome we're trying to achieve? And what is the implication on human beings, right? And how severe is it if we get it wrong? And so our governance process kind of goes through, we review everything. But we know that there are certain cases where it's a green use, right? It's one that we can say, okay, the risk to the individual or communities, we have to also look at that, is pretty low. But increasingly, if a lot of personal data, if it's a debt, model that's going to be used by our banks, if we're looking at fraud and we get it wrong, right, or we get it right, it begins to go up a meter that we begin to look at, and that means more and more eyes have to be on those outcomes and outputs. And I think that's going to be the methodology that many, many firms begin to adapt, because the more sensitive those outcomes to the world, to that output, right? So for us, cybersecurity, when we get it right, that's great. But when we get it wrong, we need to really understand why we're getting it wrong. And it needs to go through increasingly levels of review. And I think we will be in compliance with all the laws.
Yeah, and I think, again, the difference between regulation and governance, right? Governance within your company. Sebastian this morning from Salesforce talked about a lawsuit. It happens to be, I think it's Air Canada, where the customer queried a bereavement policy. The GPT sort of hallucinated, gave wrong information. And this goes to, I think, one of the earlier speakers talked about indemnifying the client. Will the tech platforms ultimately indemnify the client, which I think we know will probably not happen? But Jeff, when you start to think about how people are using these, foundational, these public LLMs versus proprietary models, and the governance in those use cases, so when you start to see these lawsuits and things happening, what are the frameworks that organizations and companies need to be thinking about their governance policies, about how they're deploying and using these models? So
it's just as JoAnn said, where you need to have a recognition of different operations bring different levels of risk, and then you need to have different levels of oversight there. So regardless of large language models or any other form of model that uses machine learning, they can be used, sort of provoked by an adversary into doing the wrong thing. A competitor or adversary can be affecting your training data so that they learn the wrong thing. They can also reveal the wrong thing in terms of violating copyright or, sort of patient data and other sorts of information that you may not want revealed. And so thankfully, for at least some categories of machine learning, there are technical techniques used to improve the security along all of these fronts. However, it's by no means definitively solved for all of machine learning. And certainly with large language models or any subsequent generation of machine learning that we see where there's this new paradigm, we're going to have to relearn the solutions for all of those things. So in as much as you have some business case that's not particularly high consequence if there's a screw up, right? If it's just, did I serve an ad at the right time or not? Absolutely go nuts with deploying the things, because if there are errors, you can shrug it off and learn from it. But as it's the case that you bring into more high consequence situations, you'll need more oversight. I work in national security, including things like military use of AI, and tell you what, if we're talking about a kill decision, we need to have a lot of eyes and a lot of consideration as to what exactly was the process there. And even if there's not a person in the loop, it's all AI, you just want to have that be interrogated to hell before you're deploying it. So you have this continuum of oversight that you need.
Yeah. Josh, can I just add one thing to that? The Air Canada example and some others we've heard about today bring up the confidence issue. And I think both for explainability purposes, and this I think goes back to JoAnn's industry, where if you're going to deny a loan decision or a credit decision, you are regulatorily required to explain why you did it. And it's not just because the model told me, right? So
that doesn't go over well as an explanation.
Well at all. In fact, it's illegal. So both for explainability and for these Air Canada kind of issues, and some of the other ones that Jeff's going into, I feel like the industry really needs to grow into the models providing information they already have, which is a confidence factor. to say, I'm answering your question about Air Canada's bereavement policy, but be aware, it's not completely clear. I'm 65% confident in my answer, but I could actually be wrong, right? And similarly with all these other examples. And I feel like that is, in part an answer that we need to get to pretty quickly to what we're now addressing here with hallucinations and wrong decisions.
But I do think that we're going to be required regulatorily, right, to also document, right? So there's going to be a fair amount of inquiry by regulators, right, as to how you got to your answer. And I think one of the challenges is going to be what I do today, right, may be best in class science today, but in 6 months it may not be, right? And this, I think, is going to be one of the challenges of our generation of AI experts, if we call ourselves that, in that, what we do today may be best in class, but 6 months from now, there's going to be more information or maybe better techniques that we would deploy. A regulator may come in 6 months from now and then query what I've done 6 months ago and ask, why was that the case? Right. And so we're going to have to document the rationale, the reasoning, based on what was available at the time something was actually, I hate to say, generated or used, right, or put into production, even if you've improved it, right? And there was a question earlier, I think, in one of the discussions about how do you monitor, right? You can't monitor all your models. And the answer is you kind of have to, right? You have to, in your operations, in your production, you have to begin to do this.
They'll have to be able to roll back when you think about these models,
roll back
right?
Or improve,
They're these neural networks. They're learning. The answer you get right now may be different 3 minutes from now, based on.
Right.
So the ability to prove that decision was made at that time.
But what was your methodology? What was your review process? What was your risk management process, right? So the question on the budget, right? How much are you going to put in innovation? How much are you going to put in risk management? I think the answer is now that it's a team sport, right? No more is it just innovation or risk management. I think everybody's at the table at the same time now for the innovation process, so that you have lots of different eyes on the innovation now, so that your law department is with you, right? Your privacy team, your security team is with your product folks, right? And your technology teams, because you're actually doing that innovation in an iterative process to kind of get to the best answer.
Right. So, David, Jeff mentioned sort of copyright law, right? So certain laws are being applied no matter what the technology is and the decisions being made. Another lawsuit I saw today was Old Navy being sued for wiretapping. So wiretapping built, the law 1967.
Say more.
Yeah, I was going to say, I don't know.
These chat bots are recording the information.
Okay. Yeah.
And now people are coming saying, well, you didn't tell me that information is being recorded. So they're trying to apply case law from 1967 saying that falls under wiretapping. Are we just going to start to see these new lawsuits bubble up as these technologies emerge and people try to navigate? And then the second part is the transparency, right? If you're making sure you're clear with the consumer in this case that it is an AI bot, it's not a human, that it is being recorded for optimizing the models, where will law have to go? And then again, where will transparency, and that's really for all of you, where will we have to start to really be transparent around how we're using the data?
Yeah, well, Josh, this is another good example of where I'm not sure the law really needs to change. So the wiretapping law has been around for a while. And as you explained the example, I recall a situation I was involved in just last week where a client in the UK turned an AI note taker and summarizer on a Zoom call. And so it was on the call as another participant. It took notes. It was an international call, Zoom, initiated from the UK, but another party in Nevada participated. And Nevada,
you
can see where it's going. Nevada, I think, like California, is a two-party consent state or something like that.
Yep.
And consent wasn't gotten, and the client then comes back and says, did I violate the wiretapping laws? And the answer is, well, yeah, you kind of did, right? You recorded a conversation. It's recorded by an AI transcriber and note taker and summarizer, but it's still pretty clearly a recorded conversation, and you didn't get permission from the other party. So I think your example and the one that I'm recounting, to me, are actually pretty straightforward examples of the current laws applying pretty clearly, and people will just need to get used to them. And the AI transcribers themselves can be helpful in starting off the meeting by saying to everyone, recognize this conversation's being recorded. If you don't agree, say something now or get off the Zoom.
So Zoom itself right now says, obviously we've learned this conversation is being recorded. I think probably early on during the pandemic, I don't remember doing that. And then someone probably said, you need to say it. Now, yes, those bots are showing up. There's a bunch of different ones. Now, Jeff, obviously in the private sector versus how government thinks about these things is different. But is it, right? Sort of where does, how we're thinking about applications of these technologies in the private sector versus how government is starting to use it, especially in defense. Do you see that those, are completely separate or where do they meet sort of in the middle?
I see them as almost entirely related. Because it's really not so much the distinction between government and private sector for these purposes. It's the size of your bureaucracy and thus how quickly you can move and how many different pieces of your operational puzzle do you have to be attending to in order to see how some things are going to interact for good or for ill. So some of this is, David said something about how we're all just going to have to learn. So I think that's 90% of the story of the humans learning what's up with the AIs and getting used to using them and figuring out where they're strong, where they're weak. So we've been at RAND, at the Technology and Security Policy Center, running various experiments of humans using large language models for different purposes. And one of the things that we identified really early on, which was a thing I hadn't realized, is that there's a massive effect of whether the human is familiar with LLMs in terms of getting anything productive out of it. And I really feel that we're sort of sitting in 1990 with different categories of people who are familiar with browsers versus not. And so you'll have people doing the equivalent of typing out a full question into the URL bar of like Netscape, not understanding that doesn't hook to a thing, right? And so I think that sort of human education and empowerment is going to be most of the story for any of these organizations. And so we heard from J&J earlier about what they're doing with education and so on. To your question and sort of relating to some things that I described earlier, the consequentialness of decisions is the thing where government is able to go large in a way that private sector can indeed with very large companies like Mastercard, but can go even bigger. And so this means that because those are consequential decisions, you're going to have ever more rigor around the safety and security and sort of fully considered impacts of using automation or AI in there, which unfortunately means that on the margin, we should expect it to be slower, but once it's actually implemented, it should have a larger positive effect.
But so to your, sort of comment about asking, consumers about LLMs, we've all heard the cases and within companies, we heard Jim's response about allowing employees to use them and them feeding the LLM with proprietary confidential information, thinking, hey, wow, I'm going to use this to help write my next press release. Oh, I just put up what our earnings are going to be, next quarter. And creating new models, right? Models where you're using the public LLM, but having, again, all the information stay proprietary. How many consumers, we start to hear about, someone talked about earlier, nutrition labels around data usage, and that's starting to be happening. How do we, at scale, educate, society, employees on really what is happening behind this? We heard, ByteDance, TikTok, right? People were pushing back. How is that data being used? But how do you guys see as far as being able to communicate that and really educate the market at scale about how this data is being used? And JoAnn, maybe start with you, because obviously this touches consumers and so important.
So we're a B2B company, so let me start there, but we are a B2C brand. And it's interesting because I know Jim and we're part of this, the Data and Trust Alliance, and we talk about these things a lot. And Mastercard, it's interesting because we've been on a journey with data for quite a while. And we talk, it's been interesting to watch the journey evolve, right? So we evolved from being a payment processing company into a technology and data company. And back in 2018, we released data responsibility principles, which was when we started really ramping up on kind of what we now call traditional AI, right? Machine learning. Because we needed all of our employees to begin to think about data as a resource in the firm. And so We started, of course, with privacy and security, given what we do, the security of payments, right? For those of you who are not know, Mastercard sits in between the banks and merchants, right? We facilitate payments. We are not a bank. Please don't come up to me at the break and ask me to fix your card. I can't do that. Please go talk to your bank. But what we do is we actually facilitate the payments between the issuing bank who gives out your card, your credit or debit card, and then we facilitate the acceptance network of all the merchant locations around the globe. And then we work with governments and other society organizations to actually then create insights based upon our data and others. And so when you really think about it, privacy, security is like job one for us, right? If the payment isn't secure, well, then what's the point of actually using a card-based product or any form factor on your phone or otherwise? But our principles actually took off like lightning, right? And it included things like accountability and transparency. It included making sure that we actually began to think about bias mitigation. Social impact. We have a big commitment at Mastercard to not only use our products for commercial use, but also for social impact purposes, because we believe that everyone on the planet actually needs to be thought about for financial inclusion. And that includes data, right? And we haven't talked a lot today about kind of the data deserts that we have and how that also impacts all of the products and solutions that AI is generating and all data products. And that our point of view is very slanted right now in AI and generative AI because it grew up in this country based on information that's predominantly US-based, West Coast-based, right? It's getting better in Europe and better with the rest of the world, but that's part of our commitment. Because of those principles, we started educating our employees about all of our products and services. And from there, then our governance process really took off for all product development that was based on data. And data is now that resource that our firm uses, right, for creativity on services, including all of our fraud, cyber, econometric type of products and solutions, our loyalty products. So when we're doing AI, it was like the next leap forward. And then generative AI is the next leap forward. It makes it easier then to do the training that we're talking about. But it's interesting, right? Because private companies are actually held to a higher standard than government. We're held to a standard that we have to get it right for our customers. And Mastercard, we operate an ecosystem, right? And so if you think about it, we have to get it right for everybody that really passes data across the world. Like by the time I finish speaking, something like 10 million transactions have been processed. I've also had, I can't remember the statistic now, but the number of incursions on our system of people trying to get at our data is equally high, right? People want the financial transactions. So we have to think about both sides of the equation, and all of our employees have to be engaged in the conversation and in the new technology if we're going to succeed, both in continuing our business, but also innovating for the next leap forward. If you don't do that every single day, you're keeping some of your employees behind you and you're not innovating. And so you also need all the governance. So when all of this started last year with generative, OpenAI, we immediately came out and said, yes, we want you to innovate, but here's the proprietary data set that you will not use. But we will give you synthetic data. We will give you data sets that mimic so that you can go out and innovate. And then we came out with immediately, what's the governance process for the innovation moment so that you can come to us and we can start generating the use cases we've all been talking about.
So obviously the data keeps coming up, right? The training data that's needed to make more accurate models, all of this. David, again, now we go to IP and the New York Times case was mentioned. All of this data that's IP protected, that's sitting in the public domain, that's being ingested into these models. Then how do we take that to the next level of really starting to understand the models, the data they're using? I know we talked a little, maybe this is a use case for blockchain of data provenance and starting to think about where data is coming from. But if data is the lifeblood of these models and it's being, taking publicly of, IP protected data, where do you sit and how do you start to, govern and put, guardrails in place so that data is not used?
Yeah, big question and a lot to unpack there. So first, the data itself, setting aside like New York Times articles that are protected by copyright, data is actually not protected by copyright. it's only protected under the law by trade secret protection, which drives back into the discussions that the panels this morning were having about how much data to be transparent about and to what extent. There's security issues and like privacy issues and consumer information issues. And then there's just the fact that if you disclose data, even if it isn't personal or otherwise secret, it is not protected anymore. So you've got a natural impetus on the part of those who are in possession of data, creating or accumulating data, to not disclose it. So you've got that as, kind of a backstop. Within that domain, right, and again, setting aside the copyright issues for a moment, there is no country in the world. Interesting that Japan came up this morning, because as that was mentioned, I was thinking, that's the second proactive comment I've thought of or heard of about Japan recently. Japan is the only country that has got ever so narrow a law that provides some kind of sui generis recognition of data rights. No other country has that, including the US. Some would say the GDPR is a sui generis privacy right for privacy data. But setting that aside, Josh, I think the answer to your question, and this is like sort of wide open thinking for government policy, is that a form of protection is needed for data other than trade secret that recognizes its non-rivalrous nature and therefore the social value of having marketplaces in data, being able to trade data. And that does not yet exist. Whether that takes the form of government incentives, like positive incentives and safe harbors, in order to encourage a marketplace to form in data, I don't know. Maybe that would be one approach, as opposed to like a government regulatory scheme that seems like much bigger of an overhang. But I think on a policy level, our country and any country that can put together enough of a backstop government incentives to encourage marketplace formation will be very much advantaged. And the last thing I'll say is that why do I go off on a tangent about marketplace formation? Well, it is well known that trade secrecy tends to be an inhibitor to marketplace formation. It is hard to do deals involving trade secrets. You get trust barriers, you get issues with once you disclose the data, it's gone and you can't get a deal done. So historically, it's very hard to transact in assets that are only protected by confidentiality. If you could overcome that with data, with some kind of a protection scheme, it could be a very powerful incentive to marketplace formation.
Yeah. And I think a part of the marketplace is monetization, right? If I'm able to actually allow my data to be used and be compensated for it, and it could even be financial compensation, as long as I could pull back that data, right? We all know, again, once it's in the model, it's there.
That's the challenge.
That's the challenge.
And that is, and I mean, just to kind of continue the thought, that's a big challenge. I mean, this is not a new concept. This concept has been around. One of the challenges is that your data does not exist, though, individualized, right? So data sets, your data, individuals' data. First of all, privacy data laws are not the same, right? So in the European Union, right, your personal data is considered an extension of your personal self, right? So it is protected as if it is you, right? We do not have that same methodology here in the United States. We have what's called the sectoral approach, right? So your financial data is protected one way, your health data is protected another way. So right there, that discrepancy is also going to be really interesting to try to put a marketplace together. The other challenge is this. Think how many places you have given your data away to. So the data sets are not unique. And so to create a marketplace, how do you do that exactly? My data set exists at banks, right? But the vastness of my data set at Mastercard is unique, right? Because I have all of it. But I only have certain pieces of it where the bank has extensions of it. Same thing in the medical field, right? So hospitals have one set of data sets, but doctors' offices have a different depth, right? That's going to be the challenge of a marketplace when data is so fluid in society. And then you have where there's been so much ubiquity. The challenge is we can't put the genie back in the bottle. It's an interesting challenge, John. We should talk about this at the DTA, right? That these devices that are always on and collecting so much information, de-identified, doesn't have to be even personalized, but we all know location data is that proxy for personalization, so it can be traced back to me. How much information has already been left out of the bottle? How do we marketize that? These are some of the trade issues that have been placed before, like the World Economic Forum and others, that we have yet, the OECD, the United Nations. Lots of folks have been trying to come up with the marketplace and trade angle on data. It's a
to your point, I mean, data portability in healthcare has been a conversation going on for decades, right?
Yeah.
Of how do we
Right.
actually, how is our data portable? How do we move it across?
And the utility of that now with artificial intelligence, we haven't talked about that, but the utility of finding solutions, right? I mean, we would not be sitting here but for the utility of data for the COVID vaccines, right? And how, it's a different purpose than maybe people provided information. Right? You give your data for one disease, but it might turn out to be useful for another. How do you get those permissions if we follow today's requirements? It is really, really challenging.
In a minute, we're going to go to questions. So for people, we'll have the mic handlers. So Jeff, one thing that hasn't come up yet, it came up at dinner last night, was U.S.-China relations, and especially, again, as we think about competitiveness, but also as we think about data. So, I brought up, TikTok and sort of the data that it unlocked. Huawei obviously had a core network that allowed data flowing, and it was come down to a, sort of a national security issue of why this allowed. We're seeing things now. Temu, now they're accusing of Temu opening backdoors to data that's on your device. From a defense side, especially again in this U.S.-China and this global, how do you then start to think about the national security and how consumers and companies can be protected? Obviously, is that a worry? I'm assuming yes. And then from there, kind of, what policies need to be in place and how do you think about that?
Yeah, it's definitely a concern, and it should be a concern for every country vis-a-vis every other possible country. It's not purely a U.S.-China story, and if you're a company, it's not just nation-state actors. It's all sorts of script kiddies up through advanced persistent threats, like from a state-level actor. And so the notion of, okay, who's got what data about me or my company or my operations exactly, and who is holding it at rest, but who is also touching it as it's in movement, and say, okay, but what laws is that company answer to, are all things that you need to be attentive to no matter what line of business you're in. Thankfully, again, there's the sort of principle of how consequential is it if something goes wrong that can be applied to all of this. Now, sometimes it can be sort of non-obvious that, if actually they've got everything that's happening on my social media account, including things that are public, yes, but also private things like just when I'm logging on. And if they know that very well, and they know that for everybody in this city, then that might allow you to do certain operations that you might not otherwise be able to do as an adversary. So sometimes it can be not obvious, but other times it can be very obvious, like, hey, they've got all of our genetic data. That's not great. And so just being able to segment out the different categories of data that you want to be concerned about is sort of step one of the process.
Josh, can I add something to that? So in the category of new executive orders from the administration that link to Jeff's point about genetic data in China, no less recently than 2 days ago, right, the Biden administration put out another executive order. This one on sensitive privacy data, not exactly like PII under GDPR or CCP in California, but it overlaps. But interestingly, one of the categories is genetic data, and this new presidential executive order that's already been proposed for implementation by an ANPRM, an advance notice of proposed rulemaking for those who didn't serve in the government. So they're moving very quickly. Designates a number of countries of concern. Think Cuba, think Korea, North Korea, but also think China, right? And so you're going to see now for companies like Mastercard, right, et cetera, now a whole new overlay required to manage certain kinds of information, like genetic information, but other information as well, to avoid having it go in. Particularly China is probably by far the most relevant country because so many of us do business there. So you're going to see another overlay in this sectoral approach that the U.S. takes.
Yeah, that's true. And then if you just think about how much we now, and when we haven't really talked enough about AI and generative AI, but how much facial recognition, right? Robotics, we haven't talked about that, and how much it only takes a snippet of facial data, voice data to actually create mimicry and what that will do. And I think that's where the thrust for some of the new regulations.
Right. Yeah, we have a question over here.
Yeah, so I think one thing in a lot of Can you hear?
Yeah,
okay,
now we can.
Great. So I have two questions basically. One is for David, and you mentioned about the lawsuit regarding like New York Times. And now let's assume like that kind of lawsuit being sought out down the road. My question is for the output actually generated by all this AI, who is going to own those output? Like for example, I use Midjourney to produce a photo. Is that the person who actually write the prompt to produce a photo, or the platform actually provide the technology? So that's one question I have. The second question I have is for JoAnn. As a Mastercard, like a company like operate across all these different countries, different countries might have a conflict like regulation regarding like how to handle AI privacy issue and so forth and so on. How do you going to adapt to that kind of operating environment? So that's two questions I have.
You want me to go first?
Go ahead.
Okay, so great question. So this is a question of ownership, proprietary interest in the output of a generative AI query, say a Midjourney image. And kind of a two-part answer. If there's no commitment made or agreement reached between the parties, then most likely it's going to be the party that generates the image. So Midjourney, to your exact example, is going to have a strong claim in ownership. That's not to say that they can register copyright in that image, because they actually cannot register copyright. The Copyright Office here in the U.S. and just about every other like office around the world has said that purely AI-generated content, image, poem, whatever, is not registrable for copyright if it's purely generated by AI. However, the question goes to ownership, and the ownership would most likely lie with the owner of the engine that generated the image in this case. There's one other component to the answer, though, which is that I said my premise for the first part of the answer was absent some agreement to the contrary. I think there's some good news here, though, Josh, which is that a number of the generators of generative AI content are stepping forward with some very good governance. And I've done some charting of the terms and conditions that they're offering. And these terms are moving toward proactively assigning ownership of the output of their generative AI to the party that made the query, that input the prompt in the first place. So there seems to be a recognition, like a self-governance.
Yeah. And I wonder if that'll be different. We heard from Adobe earlier, right? If it's Adobe that you're licensing the tool, feeding it with your information, right? Obviously, you should own the output.
Yes.
Might be different than some of the more publicly available models.
And I suspect it may change to like movie studios, and I think there'll be some type of agreements that we'll start seeing for creative industries. So it's a space to watch for sure. Yeah,
but it's a space to watch. It is moving, and I've been pleased to see companies taking this. I'll call it helpful pro-consumer approach of saying, look, we're not going to try and take ownership of stuff that your prompts create on our engine. You can own that stuff. Right.
Yeah, the second question for Mastercard is pretty simple. We hold ourselves to the highest common denominator on laws. We try to protect individuals equally. So if the law is a consumer protection type of law, privacy law, security law, we will actually protect everyone to that highest common denominator. Now, that being said, sometimes there's just conflicts between jurisdictions that cannot be resolved, right? And so at that time, then we will treat each card holder based on where that card was issued. We do not have enough personal information to know exactly who you are because we only really get the card number. We do not get your name. We get the card number, the place, time, and date of a transaction, and the amount in both US dollars and local currency. So we have to go by where that card was issued. And so if it was issued in China, we will then go to Chinese law. If it's South Korea, South Korean law, if there's something that cannot be reconciled. But otherwise, it would be the highest common denominator is how we default.
It's interesting. I mean, the cross-border, conversation you talked about the Zoom call, right, being under what, jurisdiction does that wind up falling? We have a couple questions down here, right up front.
Thank you. One question is, sounds like because this landscape is so fast changing, there's a lot of self-regulation that has to happen within all the industries. But how do you regulate this, right? Congress and Washington with all the agencies, this is changing so fast. How can they, look, you have the FDA that regulates drugs. You have the FCC, you have the FAA that keeps planes safe. In the same way, should not there be a FAIA that can bring all this together? Because look, the IP's laws have to change. Soon, in a few months, you'll be hearing about world models. Drones will fly over and take photos of all the cities, and they can simulate a panel like this will look so realistic that nobody's going to know. So how do you do that?
So this is the thing I have a lot of thoughts about. So first, I say don't attempt to regulate AI, because AI is way too broad of a concept. I think it would be a mistake for the U.S. to try to create an EU-style AI office or regulator that is responsible for all of AI. And part of that is because for many different issues, and we've talked about several here today, things about data and privacy and the use of AI for different applications, there's already a regulator or some part of government who has responsibility for that sort of thing. I think maybe you mentioned the FTC, but there's also like the FCC and many other things, perhaps the Patent and Trademark Office. So we've already got many issues covered. I think there are some exceptions. One of the things that I work on is the national security risk that can arise from very broadly capable AIs. And so if somebody is training or creating or deploying a broadly capable AI that's predictably going to get a lot of people killed, there is currently no authority to say, don't do that, stop doing that. And so I do think that there is need for new authorities for the executive branch in the US. And I suspect that the FAA model in particular works well. That I think this should be still subject to additional analysis. But for the FAA, for those who don't know, we're all sort of familiar with the jetliners, which indeed have a significant quantity of regulation on them because they are high consequence. One, you can have a lot of people on the plane and the thing can crash and a lot of people can die. You can also drive the plane into buildings, I think we discovered, and a lot of people can die. However, if you want to go make your own ultralight as a hobbyist and fly it over a depopulated area, you are basically free to go get yourself killed as much as you want. The FAA has sort of said, we don't touch that. And so there's a set of sort of different levels of regulation that the FAA does for flight. And I think that is a similar way that it could be thought for broadly capable AIs, that the absolute frontier where we don't know what's hitting us and what the capabilities are, that should be a thing that has a fair amount of scrutiny on it. And where needed, controls, but everything beyond that that's sort of lower consequence very likely can be addressed through existing systems. It could be that some of those systems still need tweaked. It could be that some of those systems, we still don't know what we want as a society. There's certain sort of tensions between different concerns that we've talked about here today that's not obvious. What should be the right thing for individual liberty or rights or economic growth and so on. So some of those things still need to get sorted out, but some of that will happen through the courts, some of that will happen through private sector sort of acting on its own in order to sort of do the right governance thing, saying, you know, we hand over the rights and ownership and so on.
So it's back to the idea that the platform won't be regulated, it'll be the use case itself, potentially.
But it's interesting because I actually think your example is interesting because it's actually the risk-based approach of the EU in context, right? Which is sort of what the EU Act is asking everyone to do in the European Union, which is in context, AI it's really important in context because without a context, you're just trying to regulate the tool outside of a context. And so the EU Act is trying to do that, but they're struggling because they haven't given any context. So what they've done is they've said, we like the risk-based approach. Okay, all you regulators in the EU, figure it out. And that sort of is, I think, what's going to happen because you can't quite regulate this tool, partly because we don't know where its iterations are going to go. I think there's some baseline, though. I think we can agree in the harms and outcomes. And I think that's where most organizations are trying to govern right now because we also are in business because we really like our customers, right? And we want to stay in business. And the way you earn trust is by trying to do the right thing. I think the hardest part is discerning where are the outcomes, right, going to go. And so right now we're in a moment of extending products and solutions, but the next generation of products and solutions is where I think we're trying to drive to. So I agree with you, but it's kind of interesting, right? Because ultimately it is the same type of outcome that I think the EU Act is getting to, the executive order is getting to. So there may be more common ground here than we even realize, even as we talk about the different approaches.
I'll try to get to maybe one more question.
My question is actually for JoAnn directly. I found it interesting how you were saying that if upon regulation review, you want to look at the processes that the people who use the model, what steps they took, since obviously generative AI can generate different things within minutes. But my question is, since the way I see it, this technology is so heavily rooted in just the data that you're feeding it. Yes,
it is.
Models. But don't you feel like don't you feel like the main regulation would be upon review looking at the data sets they train? Because, for example, you could have several bad actors on an extreme end training the data to do something bad, or training the language model almost indoctrinating in a sense, and then look at the review of their code saying this is essentially how we trained it. Wouldn't you say that would be the main regulation? And two, in a regulation of data, wouldn't you need to have somewhat of a judicial presence because the interpretation of what is this data biased or do I just not like it, you know?
Okay, so there's a lot in that question, and I don't think everybody heard you, which is a shame, so I'm going to try. Okay. So the question is around data as the food for AI, and shouldn't there be regulation on the data that's being input into the models? And I guess I didn't have time to talk about our governance model, but it starts with the data. And so yes, there's an awful lot of work that all of us do on the quality of the data that actually goes into all of the models. And I'm sure I'm speaking for almost every organization that has been up on stage today. So absolutely. I think the challenge of disinformation, which we don't have time to get into, is a separate conversation. Your comment about should there be a judicial body trying to discern disinformation from legitimate information is going to be tricky, I think, because I don't know how we train that judicial authority to do that discernment, because data in context. I think you're going to have to, again, trust that organizations want valid information, not malinformation in their systems, and want valid information. So again, it's going to go to data provenance and data lineage that all of us who operate ecosystems are going to have to get very good at the handshakes, watermarking, other technologies to make sure we validate where is our information coming from so that we're using the right type of data as inputs and validating it as we go through the process of AI. So it's a very good question.
Yeah, I know and Josh, we got to wind up, but just to add, great question.
Yeah.
You mandate an unpaid commercial advertisement for the Data and Trust Alliance, which JoAnn is extremely heavily involved in, and at least JoAnn and I also. And the data provenance standard that's been created by the Data and Trust Alliance, which is exactly to address this issue of got all this data, where did it come from? Is it any good? Can I use it? How can I use it?
From a legitimate source. Was it from a primary source, right? Or did it get transformed somewhere along the line by a bad actor?
Great. Well, let's give a round of applause to David, Jeff, and JoAnn for joining us.